Yes, thank you, my lord. Just to bring my lords up to date regarding the housekeeping matters, in the short adjournment we started attempting to gather the objections. We haven't finished, I'm afraid. We've been working on
thank you very much, both of you, and all concerned in that. We weren't expecting it by this time.
I'm grateful, and I haven't been able to go back to chambers to update my chronology.
No, of course not. Okay. That's fine. Well understood. That can follow on in a reasonably tight timescale.
Yeah.
Let's say 7 days, shall we?
Absolutely. Yes. We'll agree that between ourselves, my lord. So, my lords, I was going to say, and I will say, that regarding Pilkington and what Lord Ridgery says there about special cases and what I say on my submissions, what one should take from that, both as a matter of what Lord Ridgery says and implies, and what follows as a matter of logic, applying standard principles such as the Thameside reasonable inquiries principle and so on. I say it strengthens the case well beyond Lord Ridgery's where an application refers to or incorporates another. It strengthens the case that this application was so clear regarding the association justification, namely that it was needed to make the 2017 permission work, and that the authority decided it complied with countryside policy on that basis. I also say it strengthens the case that the 2017 permission had been begun, so was underway, and that there was, in the circumstances, a real risk of planning control. But I say I don't need to rely on anything more than the first of those, that it was very much what was said in the application itself and the reasons, the authority's reasons for finding policy compliance to make good my submission that incompatibility was a mandatory material consideration, because it went so directly to the justification and to the authority's reasons for finding policy compliance. It in my submission, read fairly and with reasonable benevolence, it meant that the the reasoning regarding policy compliance was flat wrong. But at very worst for my client, I say that it meant that reasoning was called intensely into question by reason of the incompatibility. And so the authority, because it was so directly concerned with its reasoning for granting, it had to grapple with this incompatibility. It was obviously material in the Samuel Smith Lim 2 sense. And, my lords, it is in my submission, it's worth reflecting just how unusual this case was. And I say that my learned friend's attempts to brush over that by reference to it being normal for large schemes to evolve and so forth really miss the fundamental points, because it's not at all usual for a planning authority to grant permission for a very large solar farm on the basis that it will export to the grid with this small 33 kilovolt substation, and then discover, as it were in hindsight, later years down the line, well, actually, it won't do that thing that was its whole point without a very big other compound. That's very unusual, and it is very unusual to have an application being made because it's necessary to make that earlier application actually work. I mean, applications are made all the time to vary things and change things, but to actually make the original thing work, to do what it was meant to do in the first place, this is a very odd set of facts. I do say that if Lord Ridgery's obiter regarding special cases in Pilkington is to be anything other than an empty vessel, then and I say it shouldn't be, then this must be a case where the authority was required to consider the plans for the application and the 2017 permission and appreciate the obvious incompatibility. And in terms of what the judge, I now emphasise, did not find, and indeed wasn't submitted below, the judge did not find, and we see this from his paragraph 27, he did not find that the authority should not have considered and compared the two. I say his finding at 27 actually means he found that they should, but then he didn't do anything with that finding. And there was no argument below, nor is there now an argument that it would be, and forgive the, I think it's double negative, that that somehow the authority could not have been expected to discover the incompatibility, in that it was not Wednesbury unreasonable not to discover it, as it were. Sorry, string of negatives, but it's not put on that basis, and rightly so.
Well, the spectrum is this, isn't it? Broadly speaking, at one end of the spectrum there is the immaterial consideration, i.e., that which should or must not be taken into consideration. Then there is the material consideration which may be taken into consideration.
Yes.
And at the other end of the spectrum, if I've got this logically right, there is the mandatory material consideration. And so the other side doesn't have to say that they would have been erring in law if they had taken it into consideration. They only have to say that it wasn't something that they had to take into consideration.
That's absolutely correct, my lord. Yes.
And that they wouldn't have gone wrong if they did take it into consideration, but they didn't have to.
The point I make, which is a nuance, is a nuanced one, and it sits within that, is that it can sometimes be said in cases that considering the Thameside duty, which I of course accept, the Thameside duty of reasonable inquiry is one that's subject to the Wednesbury test. Of course it is, but it can sometimes be said, one was not. It was not Wednesbury unreasonable not to discover this, and that's not said here rightly. It said it was Wednesbury unreasonable not to have regard to it, but the actual discovery of it, that's not a point taken against me. And as I say, the judge's paragraph 27 is in my favour on that, my submission.
Yes.
Yeah.
All right.
Yeah. So, and of course, the reason I say that point isn't taken against me is there was nothing more obvious than one could do than hold up the two plans. And I know my Lord Justice Limbaugh Coulson will be familiar with this concept, but of course because the plans form part of the 2017 Planning Permission, in accordance with well-established case law, the Barnett case, Lord Justice Keen's confirmation of Mr. Justice Sullivan, as he then was, comment that in a full application the plans and drawings form part of. They form part of the permission. So it wasn't as if these plans and drawings were somehow buried somewhere. They were absolutely part and parcel of the 2017 permission. And I'm not asking my lords to find in any way that the authority was required to delve into some technical detail. It was just basic, as I've shown my lords, rudimentary comparison, a reading of plans. In circumstances where I say the authority had to consider the 2017 permission because of what the application said about it, and of course they had to read all the application documents for the 2021 permission. I'm not going to take my lord to it, but by way of example, there's a case. My learned friends refer to the case of Balajigari, and others in the Home Office. And it's in the authorities bundle. It's there for the proposition that I accept that the Thameside duty is it's a Wednesbury duty of reasonable inquiry. But my lords could helpfully take the time, not now, but just to read the head note and paragraph 63 and then 70 to 72 of that judgment, and see what the claimants there were arguing. It was a case about the Secretary of State for the Home Department and whether leave to remain should be granted, and the reasons for not granting leave were because there was a discrepancy between earnings declared in the application for leave and the tax returns submitted. And it was said, well, the Secretary of State should have gone to HMRC and made inquiries about whether the discrepancies were due to dishonesty or not. I mean, this.
Sorry, the references again in Belgic.
So head note, and then 63, paragraph 63, to see what the claimants were arguing, and then 70 to 72 to see the lack of obligation to make such inquiry. But I simply flag it up by way of an example of a wildly different set of facts. Our facts could not be more different. The planning authority had the 2017 permission, including its plans, before it had granted it. It had been expressly referred to it by the application, and the development working with it was relied on to justify the application in countryside essential policy terms. Now, I've already taken my lords to where I say the judge, in addition to the overarching failure to find mandatory material considerations, where the judge went wrong in terms of an understanding of what's maybe material in planning terms. The learned judge also went wrong in my submission because he lost sight of the need to focus on the application and the justification it gave for the proposals, on the evidence before the planning authority and the authority's contemporaneous decision-making reasoning. And the judge lost sight of this because he concerned himself with whether the interested party had, quotes, other options. And the judgment spends, which these were entirely ex post facto matters. They were not something in any way averted to or considered by the authority at the time. They weren't even in evidence before the authority at the time. And we see in this run of paragraphs, J15 through to J23, and then picking up again at J29 in the judgment. What the judge certainly appears to do is rely upon these ex post facto, or the interested party had other options, to excuse the need for the planning authority to consider the question of compatibility and also the consequence. And I say it's the wrong approach. It's the wrong approach because these other options they ran counter to the justification given for the application itself. They ran counter to the authority's contemporaneous reasoning. They weren't in any way advanced before the authority at the time. And what they cannot do, and they should not do in my submission, they should not turn, as it were, what would otherwise be a mandatory material consideration into a non-mandatory discretionary consideration. And I don't know if I'm stretching the what's said in my learned friend's skeleton too far, but what my learned friends say in their skeleton argument, perhaps we just turn that up at paragraph 41. Where they explain why they say they, as it were, introduced and made reference to the other options, namely to demonstrate the fallacy at the heart of the appellant's case that a breach of planning control was likely, or at least a real possibility. So now, what I say is that these other options cannot, on any view, they can only go to that question flag there, only potentially go to that question of how real the risk of a breach of planning control was, what I've called the consequence. What they cannot have any determinative bearing on is the incompatibility, whether the LPA should, as I submit, have had regard to the incompatibility. They can't rob the justification for the application or the authorities' reasoning on the application of their potency in that regard. But I say that because the judge didn't approach matters sequentially, didn't ask, well, first of all, as I invited him to do, was it an error of law not to have regard to the incompatibility? Then after that, the consequence, the judge missed that. Now, I run through the other options in my skeleton at paragraph 74. Mindful of the time, I don't propose to go over that with my lord. But I'll just make some short points. Mm-hmm. First point is that none of the other options were before the LPA or were considered by it at the time. Second, they all conflict with the basis on which the application was advanced and the authority's actual reasoning in terms of policy, compliance and granting it. Third, they would all require some other application for planning permission. And that's the case even, I submit, in case of option 2, where whilst that requirement isn't expressly stated in the option, it's very difficult to see how, if there was some corporate off-taker, that they could be connected to without planning permission for the necessary infrastructure. But I have a further submission about option 2 in any event, because, and this applies to them, to option 2 and others, it's questionable whether they were realistic options on the facts in any event. Option 1, the first limb, and option 3 involve quite complex area of planning law concerning section 73. And as my lords know, Mr. Justice Morris very recently quashed just such an attempt. And as for option 2, and I start here to segue somewhat into what's covered by ground 3, but it's also relevant here. There simply was no such customer on the site or immediately adjacent to it, nor was there a shred of evidence of one, even in the evidence in response to the judge's question posed at the end of the hearing via the witness statement from the interested parties, Mr. Redpath. No, there was no evidence of that at all, and I do say that on the evidence before him, even allowing for Mr. Redpath's statement, the judge's finding that an off-site connection was in any way a realistic option was simply not justified on the evidence.
Finding of fact.
Was a
they
finding.
don't understand the grounds of appeal to extend to challenging findings of fact.
In respect of that aspect, they do, my lord.
Which ground is that?
It's ground 3.
I thought we hadn't come on to ground 3.
No, I haven't. I said I was segueing somewhat into ground 3.
Was fairness.
It's fairness, but also an unreasonable finding of fact in relation to draws conclusions on that re-engineer question that are wrong on the evidence, and that's the particular point. As I say, I'm not proposing to take much time with ground 3. As I say, what the other options argument cannot do, it cannot erase or dilute the potency of the justification of the application, the evidence before the authority, and the authority's reasons for finding policy compliance. Now, I turn to the consequence, and the consequence, namely the potential real risk, I say, of breach of planning control, which I say is of itself a mandatory material consideration to which regard should have been had. Now, and I do say that the grant of the 2021 permission created that real risk of a breach of control, namely that an attempt would be made to build out both the 2017 permission and the 2021 permission, which obviously could not be achieved lawfully due to their incompatibility. And I say that for a run of reasons. That the first is that the 2017 permission had been begun. The second is that the 2021 permission was justified on the basis it was needed to make that 2017 permission work. So there was every reason to think the interested party would wish to implement it if granted. The third is that the 2021 permission was granted with no pre-commencement conditions. So there was nothing to stop the interested party or another developer implementing it immediately. And fourth, point I've already made, it was accepted that beginning the 2021 permission would render continuance of the 2017 physically impossible. And that then invites, fifth, the obvious consequence that as soon as it implemented, and of course I appreciate entirely my Lord Coulson's point, well, this is all if the interested party began the 2021 permission. But if it did, then it either had to immediately stop building under the 2017 permission, or there would be a breach of planning control. And I do say that in these very particular circumstances, in granting this permission, the planning authority was creating a real risk of breach of planning control. I say that this is it's a standalone mandatory material consideration. It's standalone. Firstly, because the planning regime sets its face against a breach of planning control, and that means that on the facts of this case, the regime by implication, and this is Samuel Smith Lim 1, it required the planning authority to have regard to this real risk of a breach of planning control. And second, equally engaged Lim 2, because it was clearly what was the whole point of the application, to build the 2021 permission with the 2017 permission. Even if, for reasons that I cannot myself see, that wasn't entirely on all fours with the case law regarding what is material in planning cases by way of considerations. The particular facts meant it fell into Lord Scarman's Westminster exception category, and was extending that, obviously, material in the circumstances. Now, I want, at this point, if I may, to deal with my learned friend's arguments concerning Section 31(2)(a) of the Senior Courts Act.
Well, is that something that could come at the end in reply?
Could, yes.
Once we've heard those submissions.
Yes, of course it could, my lord. Yes, yes, by all means.
We don't know quite exactly, well, we've got an idea of what he's going to say, of course, but might it be better to wait until he's said it, do you think?
Yes, I'm very, very happy to hold those back. Right, well, those are my submissions in relation to grounds 1 and 2,
Yes.
subject to what I have to say regarding section 31(2)(a) in reply.
Mhm.
Now, ground 3, my lord. Ground 3 is it is a compendious ground, and it does cover a number of pages. It's not simply an unfairness ground, as my own friends have understood it. It also contains within it the point that I've already made, that there was simply no evidence on which to find that there could be a corporate off-taker, and indeed there was a distinct lack of evidence regarding all the other options. I would emphasise, and I do quite candidly emphasise the point I make at paragraph 76 of my skeleton argument, that ground 3 should not be required if the court agrees with me, agrees with the appellant, that it is the planning authority's contemporaneous reasoning that matters to the question of mandatory materiality. So that certainly as regards the mandatory materiality of the incompatibility, and not whether the IP or another interested party or another developer had other options not considered at the time, or indeed evidence before the authority, or indeed whether the authority was wrong to accept the justification for the application as essential to complete the 2017 permission. I've dealt with it over several pages. I'm conscious of the time. I propose in the circumstances to ask my lords to please, obviously as my lords have, read my skeleton argument and not elaborate on the submissions there. I'm not going to be able to usefully elaborate on them.
Well, you can rely on us, certainly, I assure you, to read those paragraphs carefully, bearing in mind that you haven't made oral submissions on them, but your argument is essentially deployed in those paragraphs.
Yes, it is. So I'll just turn my back.
Of course.
Thank you. I'm very grateful, my lord.
So you've got nothing to ask? No, thank you.
I'm very grateful.
Nothing to ask. So I do just have one quick point. I'm a little troubled about one aspect of the argument about risk of breach, which is how far is it right, as it were, to assume or be worried by the possibility that an independent operator might act unlawfully in the absence of any compulsion to do that, and in the absence of any past history suggesting that such behaviour is at all likely. And we're dealing with a highly technical area, construction of solar farms and so on. The operators in that field are likely to be very experienced, and they all know they have to check out the planning permission and get their own advice probably on what they can and can't do. So why should the planning authority really be concerning itself with that aspect of the matter?
Yes, my lord. In this case, again, all comes back to the facts of this case, because it's quite apparent, reading the letter from the interested parties' planning agents, that they, when they're writing that letter, they had not appreciated that there was incompatibility between these two permissions. Sorry, between the application they were making and the 2017 permission.
Your case is, it's absolutely obvious to anyone, including an ordinary lay member of the planning committee.
Yes, it is. Yes, it is. Yes, but that rather, well, curious inadvertence on their part leads to the obvious inference, I say, that the authority had to work on the basis that there was at least a real risk that the interested party was going to try to build them both out, and it is a technical point. It's a technical point because it's necessary to understand the fine grain of the Pilkington rule as explained in Hillside, which I've been over with my lords, but because it is necessary to understand that the minute they started building the 2021 permission, if they tried to do anything, build out anything more under the 2017 permission, that would be a breach of planning control. And it's entirely, I say, fair as a matter of inference to say that that was not appreciated by the interested party, based on what we see on the face of the letter.
Thank you.
So that's my response, my lord. I hope that has some assistance.
Thank you very much, Mr.
Thank you
President.
very much, my lord.
Yes, Mr. Green.
My lord, I'm going to make submissions under 5 headings. First, the law.
Yeah.
Second, the scope of the challenge below. Third, the judgment below. Fourth, our skeleton argument. And fifth, section 31 2A of the Senior Courts Act 1981.
Yes.
I'm going to leave ground 3 in writing. Your lordship have it, and I'm going to take the same approach as my learned friend.
Right.
Dealing with the law, Samuel Smith, can I invite your lordships to turn up tab 6
Yes.
of the authorities bundle? Page 142, paragraph 31. There is a quotation from the judgment of Lord Justice Glidewell. The passage itself is a reference back to Mr. Justice Cook's well-known judgment in Credence, and partway through it says, what has to be emphasised is that it is only when the statute expressly or impliedly identifies considerations required to be taken into account by the authority as a matter of legal obligation that the court holds a decision invalid on the ground now invoked. It's not enough that it's one that may properly be taken into account, or even that it is one which many people, including the court itself, would have taken into account if they had to make the decision. The upshot in my submission is that it is for the appellant to show that the considerations relied on by the appellant had to be taken into account as a matter of law, and it would have been irrational, Wednesbury irrational, for the local planning authority not to. Forgive me, my lord.
No, I was just saying yes to indicate that I was following your argument.
I'm grateful, my lord. Turning then to our skeleton argument briefly, just for references to authorities, in the core bundle tab 4, page 36, we set out a number of propositions of law which I don't think are controversial.
Yes.
And at paragraph 6, we refer to the case of Friends of the Earth as authoritative proposition that the test of whether a consideration is so obviously material that it must be taken into account is the familiar Wednesbury rationality test. My lord, that case is not in the authorities bundle because it is common ground.
Yes.
And while we're on that page, paragraph 7, the same Wednesbury rationality standard applies to the Tameside duty on public body to make reasonable inquiries.
Yes.
The question, my lord, to be asked is not whether a consideration is obvious, but whether it is obviously material. It makes the point that if one compares the 2017 layout plan with the 2021 layout plan, it is obvious that there is an area of incompatible overlap. That's fair enough. It is obvious if one compares the two plans. But the question is that obviously material? So that's a different question.
Yeah.
My lord, moving on to principles to be derived from the case of Pilkington,
Yes.
the extent to which that says anything about an obligation to compare applications that refer to each other, that's at tab 3 of the authorities bundle. Page 82 of the photocopy, or page 1531 of the report.
Yes.
It's 1531 F and G essentially.
Yes.
And all Lord Widgery does in those paragraphs in my respectful submission is to say that the case before him, the case before the court, was not one where one application deliberately and expressly refers to or incorporates the other. So he was distinguishing that type of case, but nothing he said in my respectful submission in his obiter dicta tell us, or tell anyone, what should be done where one application does refer to another. All he is concerned with there is applications that don't refer to each other. Where applications do refer to each other, then in my submission, the test, whether one has to compare them or not, and what one does with that comparison, is the Samuel Smith test. So in my respectful submission, there is nothing in Pilkington, decided obviously long before Samuel Smith and the authorities on which it is based was decided, nothing there that adds anything to the test in Samuel Smith. If your lordship finds that the incompatibility was an obviously material consideration, then the appellant gets home on that ground. If not, then the appellant fails. Pilkington doesn't take matters any further in my respectful submission.
Yes.
The third authority, my lord, Hillside. And at the start, just for your lordship's note, I would invite your lordships to look at paragraphs 30, 41 to 46, 52, 56, and 60 to 68. I'm going to look only at paragraphs 43 and 45 first off.
Yeah.
Which set out what Pilkington actually decided. At 43C, your lordship has seen this already, what must be shown is that development in fact carried out makes it impossible to implement the second permission in accordance with its terms. So the test is one of physical impossibility. And again at 45, in essence, the principle illustrated by the Pilkington case is that a planning permission does not authorise development if and when, as a result of physical alteration of the land to which the permission relates, it becomes physically impossible to carry out the development for which the permission was granted without a further grant of planning permission. My lord, that's significant in this case, and the clarity given by the Supreme Court in Hillside is significant to this extent. If development carried out under the 2021 permission is not physically incompatible with what is permitted under the 2017 permission, it doesn't prevent reliance on the 2017 permission.
I'm so sorry, just articulate that submission again for me.
If development carried out under the 2021 permission is not physically incompatible with development permitted under the 2017 permission, it does not prevent reliance on the 2017 permission.
Yes.
So, for example, the solar panels somewhere north or south of the compound are the same in both plans.
Well, that's exactly the point I was going to take, Your Lordship, too. If one compares plans D, which is what was permitted in 2017, with plan C, what was permitted in 2021, one can see that there are areas of solar panels which are common to both.
Yes. Just so that I'm clear about this, Hillside is Supreme Court authority. In reading the last sentence of paragraph 43 just now, you emphasised, as I took it, the word, first sentence of 45 it is, if and when, you emphasised the word when.
Yes.
Earlier in the day there was discussion between the court and Mr. Burton on the question of timing, and the submission made, as I understood it, was that Hillside is authority for the proposition that the mere, it wasn't put exactly like this, but the mere beginning of development under the second permission would be enough to effectively to call a halt on further progress with the first. It wasn't put like that, but that's perhaps the gist of it. I'm not sure that you submit differently, or do you submit?
Oh, I do.
You do, and you submit, do you, that no, development under the second permission would still allow you to carry on with other development under the first permission, which was not physically incompatible with the second?
Until the point is reached where under the 2021 permission you've done something that is inconsistent with, incompatible with the 2017 permission.
Yeah. Well, standing back from all that, the answer to that ought to be found in Hillside, definitively. Do you say it's found in the first sentence of 45, or is there another passage that amplifies this proposition?
My lord, 45 summarises the principle.
Yes.
So in my submission, that is sufficient.
Well, now, in the focus in this case is not on that question, actually. No. The focus in this case, as I'm sure by now we all agree, is on the proposition that the authority ought to have taken into account, indeed it was as a matter of law obliged to take into account, or it was irrational not to take into account, the incompatibility between the two permissions, such as it, brackets, such as it was, close brackets. We don't have to determine, do we? Well, we can't determine what the law is on incompatibility because the Supreme Court's already done that. We can't differ from them. But do we need to resolve the factual question either? I mean, the question for us to consider, as it was for the judge ultimately, is whether the authority went wrong in failing to grapple with, as a mandatory material consideration, if it was, the fact of some incompatibility between the two permissions. Is that a fair encapsulation?
Well, yes. This is a side issue with all due respect, but it was raised expressly, and I indicated earlier, interrupting the learned friend, that our position was more nuanced than it was expressed to be below. It's certainly correct that below, before His Honour Judge Jarman, I indicated that once you begin the 2021 permission, you then can't carry on development under the 2017 permission. The decision in Hillside in the Supreme Court, which came out after that, has clarified matters.
I mean, look, perhaps cutting through it would be this question. Do you accept on behalf of the authority that at some point there is that moment that you described just now when the developer would be, as it were, forced to its election on whether to proceed with the first or the second permission? There is a point at which that moment comes.
Yes, one cannot fully build out both permissions.
Right, so there is that degree of incompatibility.
There, absolutely, my lord.
So an example of that could be had the developer begun to erect panels in an area that was covered only by 2021 and not by 2017.
Well, absolutely. But it does raise this possibility, and I raise it only as a possibility. It certainly wasn't considered below. The developer could, for example, build out all of the 2017 solar farm, except for the area of the 2021 permission, and then carry out that permission to its completion. So that's a theoretical possibility, my lord. It's not what the developer has sought to do. As one can see, there have been a variety of Section 73 applications to vary and so on, but that is a theoretical possibility. But it certainly wasn't one raised below, and I don't rely on it in my arguments in this court.
Right.
My lord, that's all I was going to say on the law. I'm going to move on to the scope of the challenge below.
Yes. Right.
It's said in a number of places by my learned friend, both today and in the appellant skeleton argument, that the judge below did not focus on the right issue. He failed to consider the rationale for the application, the 2021 permission, and in particular failed to look at the policy justification for it. And just by way of example, my learned friend's skeleton argument, tab 2, paragraphs 3, 28 and 42. Can I take your lordships to the amended statement of facts and grounds, please, which is at tab 10.
Yes.
The relevant ground, ground 1, the one that was granted permission to proceed, is at page 127, paragraph 59.
Yes.
And can I first invite your lordships to read that paragraph? my lord, the focus of attack is not, with all due respect, on the reasoning in the officer's report, on the policy justification for the 2021 application. The focus of the attack is on the consequences, the legal consequences, if the 2021 permission is begun or implemented. The challenge was the local authority should have had regard to the fact that if the 2021 permission was granted and begun, either A, all work done up to that point would be rendered unlawful, or in any event, all further work under the 2017 permission would be unlawful.
Yeah.
There is no reference in the claimant's amended statement of facts and grounds to the consideration given by the council to the policy justification for allowing this development in the countryside. That was also the case under the claimant's skeleton argument, which is at tab 8. On the second page, page 76 of the bundle, paragraph 5, my learned friend boils down ground 1. If your lordships would look at that.
Yeah.
Again, the focus, my lords, is on the consequences. The development control consequences, if the permission was granted, 2021 permission was granted, it being alleged that there would be a breach of planning control. Page 78, paragraph 12. Melanchthon makes the consequence very clear. The fact meant that in granting the permission, the defendant was granting a permission that could not be begun or implemented without causing a breach of planning control. This is the consequence. Nowhere in this skeleton argument is there a challenge to the way the local authority addressed the policy support or justification for the development.
Yeah.
So, my lord, the claimant's case below, certainly on paper, in particular in the one ground that was permitted to proceed, was concerned with the consequences, the development control consequences of the grant of the 2021 permission. And it was said that the local authorities should have had regard to those consequences.
Yes.
And that is why, my lord, in response, we say in the detailed grounds and skeleton arguments and so on, well, actually, it was not remotely inevitable that there would be a breach of planning control. My lord, Sir Launcelot has raised the very point. Why should it be assumed that a commercial operator is going to carry out development in breach of planning control? Given that there are options, and that is the reason why the options are set out in our detailed grounds and why they were considered by the judge below. Because they demonstrate that a developer confronted with inconsistent permissions, faced with that choice, implement one fully or the other fully, could in fact take a third course, apply for a variation of the original permission, or a variation of the 2021 permission, or a composite scheme covering both.
Is it also fair to say that, I mean, to characterize the options as being some form of illegitimate ex post facto approach is wrong, because all they really do is just spell out, frankly, implications which are there in the statutory scheme that anybody will advise to take advantage of.
Well, yes.
So it's nothing to do with ex post facto justifications
no, not at all.
That's what I thought.
Yes. Now, it's perfectly true to say, and one has the transcript, that my learned friend in his oral submissions below did take His Honour Judge Jarman to the officer's report and the letter accompanying the application and made submissions on the fact that there was a policy that required justification for development of the countryside. It had to be essential, and the authority was satisfied that this was an essential case, and that couldn't possibly be the case if there was this incompatibility. So, my lord, I fully accept those submissions were made to the judge below, but that was not the pleaded case. That was not the case on which permission to proceed was granted. The focus was on the development control consequences of granting the 2021 permission, and in my respectful submission, the judge below was perfectly right to focus on that.
Yes.
My lord, I turn then to the judgment itself. Tab 6 of the bundle. I start at page 55, paragraph 4. Where the judge records the fact of implementation of the 2017 permission and records the common ground then. It was not in dispute before me that implementation of the 2021 permission would mean that it would not be possible to complete the development in accordance with the 2017 permission, rendering such completion in breach of planning control. And that's certainly in accordance with the concession I made below. For the reasons I hope I've dealt with a few moments ago, Hillside actually provides a more nuanced approach to that. One looks to see whether or not physical works have been done which render reliance on the earlier permission unlawful. But for the purposes of this judgment, it makes no difference, frankly. At paragraph 5, there's a summary of the case below. This potential breach of planning control by granting the 2021 permission was not dealt with in the officer's report to the authority's planning committee or otherwise brought to the attention of members. The claimant, who resides near the site, challenges the grant of the 2021 permission on the basis that the authority in granting it failed to have regard to such incompatibility, failed to have regard to the fact that the 2021 permission could not be implemented without causing a breach of planning control, and failed to grapple with the incompatibility or the consequence of it. Well, that's a perfectly fair summation of the ground for which the claimant was permitted to proceed below. And at paragraph 6, the learned judge then sets out, in essence, the local authority's response to it, that there was an unwarranted assumption in the claimant's case that the developer would implement the 2021 permission and thus cause a breach of planning control. And it was further submitted that the reasons why this permission was sought for in the first place was not something that need concern the council. So he starts off, in my respectful submission, entirely on the right foot. At paragraphs 11 and 12, he then sets out a number of propositions of law. It's not suggested that he got any of those wrong, although some of them do need to be qualified now in the light of the subsequent decision of the Supreme Court in Hillside. Page 54, Roman 3, for example, there is reference to the observations in Sage that if a building operation is not carried out both externally and internally, fully in accordance with the permission, the whole operation is unlawful, not just that part which deviates from the permission. My lords, the Supreme Court in Hillside looked carefully at that at paragraphs 56 to 69 of the judgment, and they found that Sage, well, the observations should not be followed if that really was what was meant. Likewise, paragraph or Roman 4, that no longer is good law given what was said in Hillside at paragraph 63 and 68. But my lord, those changes in the law subsequent to this decision make no difference to the result. Likewise, at paragraph 12, there was a point raised in the Court of Appeal in Hillside, whether if you carry out development under one permission, stop and then carry out inconsistent development under another permission, that inconsistent development renders all of the development carried out on first permission unlawful. That was a question raised but not answered in the Court of Appeal. It was answered decisively in the Supreme Court. No, it does not have that effect. My learned friend takes issue, or possibly takes issue, with what is said at paragraph 24, or what follows from paragraph 24. Having set out in the preceding paragraphs the various options open to the developer, at 24, the judge says, the question then arises as to whether the potential difficulties arising from the incompatibility of the two permissions should have been considered and grappled with by the authority. And then the judge deals with the law, section 72, which imposes an obligation to have regard to material considerations. Refers to right as authority for the proposition that such consideration is one which serves a planning purpose. And then at 25 refers to Samuel Smith, setting out part of that. And then having set out the law, at paragraph 27, again, the judge, in my respectful submission, perfectly accurately summarises some of the submissions that have been made by my learned friend.
Mr. Green, I think there was a point that the judge referred to right,
Yes,
didn't refer to the
Great Portland Street
qualification
case.
in Westminster.
Yes, well, Westminster City Council,
Yeah.
which says that there are going to be exceptions to the general rule that planning is concerned with the character. Well, yeah, he doesn't refer to that, but there's no suggestion in this case that the consideration was anything other than a planning consideration. There certainly was no suggestion from the local authority that the incompatibility was somehow not a planning consideration. Plainly it was. So it simply wasn't a matter that was an issue. The question was whether it was a material consideration that was so obviously material that it had to be taken into account. So accepted, conceded, capable of being a material consideration, but in our submission, not so obviously material to the determination that it had to be taken into account. Again, in my submission here, the appellant is jumping at shadows. There is nothing in the judgment that suggests that the judge took the view that these considerations were not proper planning considerations. It was the so obviously material test that they failed.
So a material planning consideration, but not a mandatory material planning consideration.
Exactly so. Under 29, the judge expresses his conclusion. He expressly recognises in the second line that the options relied on by the authority were not before the authority in considering whether to grant the 2021 permission. So this is not a question of ex post facto rationalisation or anything of that sort. He was fully conscious of that, but these are options inherent in the statutory scheme. So because these options existed, the whole thrust of the appellant's case that a breach of planning control either would happen or was likely to happen or there was a realistic possibility of it happening just fell away. And just as an aside, my Lord, as will become, or is apparent from the chronology that there is, and be more apparent from the chronology that's going to be produced, this is a site that has seen a number of applications to vary what was permitted or to amend what was permitted. This is an evolving scheme, and that is not remotely surprising given its scale.
Yes.
Well, that's all I was going to say on the judgment. I'm going to move to our skeleton argument, if I may.
Yeah.
That's at tab 4.
Okay.
I've already taken your lordships to page 2, which sets out propositions of law, which I don't think are controversial. At page 3, the skeleton, paragraph 10. This was a paragraph that Maloney's friend alighted on in his submissions. But my lord, we stand by what we say in the second sentence. The question for the local planning authority is whether the proposed development is acceptable in planning terms, not what motivates the applicant. We don't know, my lord, why it is that the developer, the interested party, put the application in for the 2021 permission, seeking development that was inconsistent with the 2017 permission. It may be that this was an evolving case. It may be a mistake was made, deliberate or accidental, we don't know. But unless the consequences of that inconsistency amounted to a mandatory material consideration, that wasn't something the local authority needed to get into.
Yes.
I move on then, my lord, to paragraph 32 and 33. Again, the subject of submissions from my learned friend. At paragraph 32, the first sentence, works to implement the 2017 permission took place in June 2020. That simply reflects what was in evidence before the judge below. We then go on to say those works did not involve development within the area of the 2021 permission, my lord. We say that on instructions, we accept that is not in evidence, was not in evidence before the judge below. We thought it would be helpful following the Supreme Court's decision in Hillside to make that point clear. If it is a matter of controversy, if it's a matter on which your lordships would like to be certain, we can put in evidence to that effect. But this was contained in our skeleton argument as lodged in February this year. There was no challenge to it at the time. Yesterday, my learned friend raised the point that what we said in that paragraph, at least in the second and third sentence, wasn't evidenced, and we accept that. But as far as we know, it's not suggested that it's wrong. There's certainly no contrary evidence. But my lord, as I say, if it's important, and it may not be important, if it is important, we're perfectly happy to deal with it.
Well, I think the court would be naturally averse to receiving fresh evidence unless there was a compelling need for it. The proposition in the second sentence of paragraph 32 of your skeleton argument is not centrally germane to the issue in the case. I don't think. It may be right, it may be wrong, but either way, it's not going to affect, is it, the outcome of the issue here? Have I got that right? Yeah, I think we're all agreed on that.
In which case, I needn't take the point any further. Paragraph 33 is essentially conclusions drawn from Hillside. And Hillside made clear that mere inconsistency between permissions is not enough to render development under one or the other unlawful. There has to be a physical alteration in the land that is inconsistent with a permission before it can be said that that permission can no longer be relied on.
Well, this takes us back to
Yes, I believe I've addressed this
you
question.
addressed earlier on, yes.
At paragraph 37, my lord, moving on then, we set out the various options. They were also dealt with by judge below. I'm not going to take up any time looking at those. At paragraphs 47 onwards, page 46, we address some of the threads of Malone Friend's argument. That there was an association between the 2021 permission and the 2017 permission, and that's not controversial, that's accepted, yes, there was. But given the options available, the fact that there was an incompatibility between the two was neither here nor there, we say. And so far as the Council's reasoning is concerned, we have set out paragraph 8.6, paragraph 50 of our skeleton argument, that has already been the subject of some discussion earlier today. The point it makes, the important point it makes, is that the principle of a solar farm on this site has already been established. And so even if it turns out that the 2017 permission in its entirety cannot be permitted, or cannot be carried out, I should say, a variation of it is in principle going to be acceptable.
Yeah.
We accept, of course, the link between the 2021 substation and the solar farm. One can't connect to the grid without a substation. So we absolutely accept that. But my lord, the converse also applies. No one in their right mind is going to build the 2021 substation without the rest of the solar farm to connect to the grid. So the concern that somehow the local authority through the 2021 permission has permitted a substation that might be built on its own without a connecting solar farm, that really is fanciful.
Yes, your skeleton argument doesn't deal with paragraph 860, and that may be because Mr. Burton's skeleton argument didn't deal with that paragraph.
Well, this wasn't, to be fair, the focus, or isn't the focus of the ground permitted to proceed. But
no, but he has
yes.
made something of that paragraph today, and I don't know whether you want to say something about that.
Yes, I have to get that paragraph. So tab 13 for the officer's report.
Page 197.
I'm grateful. These were the observations of the heritage.
Oh, no. This was what was said about the alleged procedural error.
Oh yes.
It's paragraph 860 on page 197.
Forgive me, my lord. Yes.
It relates back, I think we all agreed, to the earlier passage on page 179 under the same heading, procedural error, paragraph 613. And the thrust, or part of the thrust at least, of the submission made about paragraph 860 is that it's specific to the 2017 permission, not merely to a generic or notional, as it was put, solar farm, but specifically and solely to that development as permitted by the 2017.
And I accept that is the natural inference to draw from that paragraph. But that doesn't make the inconsistency or incompatibility a mandatory material consideration.
and sorry to be naive or slow. Why?
Because whether it's the 2017 permission as is, or the 2017 permission as varied under section 73, there is no doubt that the 2021 substation can connect a solar farm at this location to the national grid. Now, I appreciate the authority, as is accepted, did not take into account the incompatibility. This perhaps brings me to the section 31(2)(a) point. But it wasn't a mandatory material consideration for the reasons we've already given. The incompatibility did not prevent a solar farm at this location making use of the 2021 substation to connect to the national grid.
So that's really a variation of your submission, your submissions within 53 and 54 of your skeleton.
And perhaps this is the appropriate moment to look at what if the local authority had expressly considered the fact that the 2021 permission and the 2017 permission permitted incompatible development in the area of the 2021 permission.
Well, is that section 31(2)(a)?
Well, it is.
All right. So we're going on to that now.
Oh, yes.
Yes, what if?
What if? An officer of the authority rings up the developer and says, do you know, you put an application in for permission for a substation that is incompatible with what's been permitted in 2017. And the response might have been, oh, we didn't appreciate that. But please grant the planning permission because we want to ensure that the principle of a substation, a substantial structure at this location, is permitted before we do anything else. We want to know that that is acceptable to the authority. Or the response might have been, yes, we know that. We know that there are these inconsistencies. We're going to come back with a section 73 application to vary the original planning permission in due course, having ensured that the substation itself is permitted. Or they might have said, yes, we know that, but we're going to come back with a comprehensive scheme of development covering everything. Or they might have come back and said, well, actually, please grant this permission. We're going to sell the site to another developer, and it's their problem then to sort out. So the developer might have said a number of things. What is the authority then meant to do with that? And more importantly, how does that bear on the planning merits of permitting the substation? A solar farm in this location had been permitted and was acceptable in principle. To connect to the national grid, a 132 kilovolt DNO substation was required. This was an application for that sort of substation. The local authority considered it was acceptable in terms of landscape impact, amenity, and so on. So why should it not grant that permission and leave it to the developer to sort out any inconsistencies between that and the 2017 permission? The whole thrust of the case, the pleaded case, was that a breach of planning control was likely to happen, or indeed was inevitably going to happen, given the inconsistency between these two permissions. And in my respectful submission, that is not remotely likely, wasn't remotely likely at the time the decision was taken. A, because commercial operators don't generally tend to breach planning control if they know what's good for them. Local authorities have very extensive enforcement powers. Had they wanted to stop unlawful development going ahead, they could easily have done so. But perhaps more important, my lord, there were ways in which the solar farm and the substation could be made to work together with modification, yes, absolutely. But there were no insuperable difficulties in this case. And so had the local authority considered these incompatibilities, it would have made not the slightest difference, in my respectful submission, to the outcome.
Has there ever been any suggestion in these proceedings or otherwise that the planning analysis, if you will, for a varied scheme, modified scheme, would be different to accommodate the 2021 planning permission substation, that there would be any different analysis, different policy matrix, different physical considerations of any kind?
Well, I don't think so.
No.
We know
It's,
that
it's an entirely neutral question.
Look, I appreciate it. A Section 73 application was made and was permitted, and that is the subject of the recent decision of Mr. Justice Morris to quash it for various reasons. But I don't believe that the planning analysis was any different. The same factors were looked at, and I believe the same policy considerations were taken into account.
So certainly the conservation officer in that passage that
yes,
Burton fairly took us to, that appeared to be addressing from a planning perspective the substation and explained why there was no difficulty. But that was the conservation officer. That's obviously an important element, but not the only thing.
I don't. Well, of course, correct me if I'm wrong, but I don't think it's being suggested that had the decision taken account of the incompatibility or whatever, that there would have been a different policy context. And I don't think it. Well, I don't know.
No, simply, in fact, my question was very carefully framed as a question of fact.
Yes.
Has it ever been suggested that was the formulation?
Yes. I don't recall, my lord, any such suggestion being made.
I see. Well, if the other side has a different recollection, then no doubt will be told. Thank you.
Well, as I indicated, I was going to leave ground 3 to our written submission.
Yeah, so you've effectively dealt with section 31(2)(a), and the proposition in that subsection is
if it's highly likely
that the decision would have been the same.
We said it is highly likely.
Yes. Right. And ground 3 you're leaving on the page, as it were.
Oh yes.
Right. Peter, anything? Thank you very much. Yes, Mr. Burton, your reply.
Thank you, my lords. My lords, I'm going, if I may, to actually start with section 31(2)(a).
Yeah.
As actually quite a helpful way to look at this case and look through the lens of 31(2)(a) at this case. Certainly, of course, one thing that we now have clear which in my submission has never before been clear, is that the authority does accept that the incompatibility, at least, was a material planning consideration, i.e. capable of being a material planning consideration. That's, as I say, it's a point that's never previously been clear, and it is now, and that's helpful. Now, what jumps out in my submission very immediately from what my learned friend has said is as I have said throughout, and as I said below, the central importance of the authority's reasons for finding policy compliance here, and then the central importance of that paragraph 8.6 in the main officer report. And in my submission, that my learned friend was unable to deal with 8.6 satisfactorily, and it's no surprise he was unable to deal with it satisfactorily, because it is clear from 8.6 that as regards what was very, very obviously a very important policy in the development plan, the reason the authority found compliance with CMO2 was because this application would make the 2017 permission solar farm work. Well aware I've said it before, but I say it again now in the context of section 31 2A, because when my learned friend, in response to my Lord Lindblom's question, says, well, I'm not aware, and as a matter of fact, it being suggested there's a different policy context. Well, what matters in my submission, crucially here, is that finding of the authority.
No, he said that he wasn't aware that that point had ever been taken.
I apologise. Yes, my lord.
He was very careful.
I truncated.
He was very careful.
Yes,
that's the submission you need to deal with.
Yes, not aware that the point had ever been taken, my lord.
Yeah, in there was a amended statement of facts.
That there was a different policy context, and I accept that. But what matters in my submission is that the policy context plainly included this countryside policy, and the authority found that policy was complied with because this application would make the 2017 permission solar farm work. It was not, I've made this submission before, but it was not a finding that it would make some notional solar farm work, this specific solar farm work that they had already granted permission. Now, I of course accept that my case as regards the mandatory materiality of the incompatibility, it does rely heavily on my lords agreeing with me regarding taking a benevolent reading of the officer report, agreeing with me regarding the reasons that the authority found policy compliance. I've taken my lords to both the start of the report, where we see these repeated references to the 2017 permission. I've taken my lords to the meat of it, as it were, 8.6. I've taken my lords to 860, and placed in context, it can only mean compliance with COM2 because it would make the 2017 permission solar farm work. And that is why my submission, my learned friend, is wrong to say, well, it's highly likely the outcome would have been the same or not materially different for the claimant if the authority had appreciated the incompatibility and have regard to it. Because that incompatibility drive the coach and horses through that essential finding on the reasoning. Couldn't do what the authority had found it needed to do to get it over that essential in the countryside hurdle. We don't know. We don't know what the authority would have said, would have concluded regarding whether it was essential, and it's a high bar, essential. We don't know whether the authority would have said of a purely notional situation that it meets the essential test, and of course there were planning judgments beyond that in the policy matrix that's discussed here. There were planning judgments that would flow from some other solution with the DNO compound in some different location. Now, my lord, Coulson, my learned friend, had the discussion regarding the paragraph I flagged up where the conservation officer says there's an amendment, and essentially I'm happy with the amendment. But what we don't know is what would have been said if the authority or even the developer said, "Oh gosh, hold on, this is incompatible. We need to move the DNO compound somewhere else." We don't know whether that would have been said to be acceptable in planning terms. We need to move them somewhere else so it can fit with the 2017 permission. We don't know that, and yet the DNO compound had been put where it was. As I understand it, I need a reference to this actually, but it had been cited where it was for specific ecology reasons, so as to be far enough away from a certain ecological feature, so on. So there were considerations that would then have had to be explored and wrestled with and grappled with as a matter of planning judgment. Now, my learned friend did refer to the grant of the most recent Section 73 permission, but that has been quashed, and I don't, obviously, my learned friends are challenging it, but I don't see how that can assist. So that reasoning for compliance is the nub under the incompatibility ground. I mean, compatibility is a mandatory material consideration point. Can't possibly be said that had the incompatibility been drawn to the authority's attention, it would have reached the same conclusion. It's highly likely it would have reached the same conclusion because it can't get to that finding of policy compliance without this application making the solar farm work. So that's by way of replying on section 31(2)(a). Now there's a couple of points on the law that I do want to pick up because it seems that there's still some confusion in my learned friend's submissions regarding regarding various aspects of the law. Now, just firstly, my learned friend went to Samuel Smith. I know my lords will not be at all confused regarding this, but my learned friend went to paragraph 31 in Samuel Smith, which is Authorities Bundle tab 6, and the quotation of the decision of the New Zealand Court of Appeal in Creed NZ. Now, my learned friend, as it were, set matters up on the basis of quoting paragraph 26 to my lord. My lords will recall paragraph 26. Paragraph 26 of that quotation it is concerned only with the first limb, as my lords know. It's only the first limb of the Samuel Smith text.
Do you want to look at this?
Yes, it's page 142 of the authorities bundle.
Thank you. Yes.
My learned friend read out the words, my lords will recall, if in the statute conferring the discretion there is to be found expressly or by implication matters which the authority exercising the discretion ought to have regard to, then in exercising discretion it must have regard to those matters. My lords will recall my learned friend said, well, that's the test the claimant has to meet. Now, that is only concerned with what I have called the first limb of the Samuel Smith mandatory materiality test. The next paragraph is the one that is paragraph 27 of the quote, is concerned with the second limb. In certain circumstances, there will be some matters so obviously material to a decision on a particular project that anything short of direct consideration of them by the ministers would not be in accordance with the intention of the Act. And it's that second limb that bears directly on the incompatibility being a mandatory material consideration because of the justification for the application and the reasons that the authority decided it was policy compliant. The next, now, my learned friend said that Pilkington adds nothing to the Samuel Smith test. Now, certainly, I accept that the Samuel Smith test is the one at the heart of this challenge. But I do say that Pilkington is of some assistance because it is an example concerned where the judge, Lord Widgery, does concern himself specifically with what should or what might an authority have to do if they are faced with an application that refers to or expressly incorporates another. So, as I've said, I say Pilkington is absolutely on all fours with the Samuel Smith principles, but it's helpful as an example of some starting judicial wrestling with the specific circumstances here. Now, as regards Hillside, here, whilst I don't say, and I agree to this extent, that the actual ultimate ratio in Hillside and whether or not one couldn't start this 2021 permission without immediately having to stop the 2017 permission, that is ultimately not a point that is decisive, because it's accepted, as my learned friend rightly did, that one could not lawfully build them both out. And I say that is what goes to the heart of the authority's reasons for finding policy compliance and so on. However, it is right that I bottom this point regarding Hillside out, because Hillside does, the ratio of Hillside is that if there is a physical impediment to completion of the whole of a permission, then one cannot build further under it.
But that's not a point for us to resolve on the facts here, is it? I mean, once it's accepted as it is,
Yes.
and squarely accepted that there is ultimately an incompatibility, I put it like that,
Yes.
there is a point at which the developer's election would have to be exercised, and that equates to an incompatibility. That gives you what all that you require for the purposes of arguing the central point in the case, which is this whole question of obviously material consideration. And unless I'm misunderstanding it.
My lord, it gives me all that I require for the purposes of arguing that the incompatibility was mandatory material. It doesn't give me all I wouldn't say that all that I require, but it doesn't give me all that I submit to the court as regards the consequence, the real risk of breach of planning control being a mandatory material consideration. And that's why I address it. The reason the reason I need to address it under there is precisely because what I understood was common ground below and is now
So you
apparently
say,
not.
whilst
common
it may
ground.
not be germane to the question of whether incompatibility, qua incompatibility, was an obviously material consideration, the fine reasoning in Hillside is material to the second question, which is whether the potential breach of planning control or the risk of a breach of planning control was an obviously material consideration. That's how you put it.
That's how I put it. That's how I put it. And I put it on the facts. On the facts because.
Are you saying? I'm sorry to.
Yeah.
Well, perhaps you're going to explain this, so I'd wait for that. I think, but the question in my mind is, what difference does it make in that particular context?
Yes, the difference it makes in that particular context, it's the difference between, on my submission, the moment the interested party or another developer starts the 2021 permission, they would not be able to proceed any further building out the 2017 permission without a breach of planning control. And on my learned friend's submission, that they could start the 2021 permission and at some point, but we don't know when, keep building the two permissions, and then at some point there would become a physical incompatibility between the two. Now, and there are two limbs to this. One is a matter of law on the principles we find in Hillside, and the other is the particular facts of this case. On the law in Hillside, could my lords please? It should not be necessary to do more than turn to the head note here, and indeed remind ourselves of paragraph 18. But if at page 87 of the authorities bundle.
Page 87.
Page 87.
Yeah.
We have this is the Hillside head note, and there are two points. We have the continuation of paragraph 1 over the page, but the nub of it is here, where two mutually inconsistent planning permissions were granted in respect of the same site, and one of them was implemented. It would be unlawful to carry out the development proposed in the unimplemented planning permission if it had become physically impossible to do so, having regard to what had been done under the implemented permission. Two, and I'd invite my lords to read two. Now, clearly, what their lordships found in Hillside is one could not disaggregate the original 1967 permission. And there's no suggestion that one can disaggregate, nor could there be any suggestion that one can disaggregate, in our case, the 2017 permission. And having found in Hillside that the original 1967 permission could not be disaggregated and split up on a proper interpretation of that permission, their lords then they find that, and this is the bottom, it followed that carrying out under an independent planning permission development on the site which departed in a material way from that scheme, i.e. the original 1967 scheme, would make it physically impossible and hence unlawful to carry out any further development under the 1967 permission. And my lords will recall I took my lords to paragraph 18 in Hillside, which I refer my lords to again.
We had the same debate. This is on the basis that the work didn't comply. The work actually physically undertaken didn't comply with the first in time planning permission.
It did not, my lord, yes.
That is not this case. As a matter of fact.
No, it's not as a matter of fact, my lord, no. But in the hypothetical, which is what I am advancing as part of my submission, that there was a real risk of a breach of development control.
Your case is it was inevitable.
No, I don't put it that high, my lord.
In your statement of facts and grounds.
I did put it that high then, and I do not put it that high, and I didn't put it that high below.
Are you differentiating the risk? Are you saying that there is a real risk if the law is X, but not a real risk if the law is Y? That's why I asked you the question I did just now. What difference? I mean, Hillside is Supreme Court authority, which very thoroughly examines the jurisprudence up to that point on these matters, and sets out a very full analysis. It's not for us to go behind that, to gloss it, to summarise it might be risky in itself. We're bound by that. But ultimately the question for us, I think, which is the question I think I'm asking, is what difference does it make whether your interpretation of Hillside is right or Mr. Green's as to this question of real risk? You know, it would be open to you to submit that the real risk is the same either way. But that, I think, is not your submission. You're saying that there is a difference in the risk depending on what interpretation you put on the law.
I am saying that, my lord. I'm saying there's a difference in the degree of risk. My interpretation of Hillside is that, and I will put Hillside now into the facts of this case, or rather, of course, taking my lord Coulson's point, which I hope I have always fairly tried to make clear is my case. If the 2021 permission was begun, then on my interpretation of Hillside, bearing in mind, and I'll come on to this, bearing in mind the factual common ground below, that the moment it was begun, it would be physically impossible to build out the 2017 permission. Therefore, the moment the 2021 permission was begun with doing something, it would be a breach of planning control to build out anything further under the 2017 permission. But
as a matter of common sense, that can't be right, can it? Because if you take the panels to the south of the site, they were precisely the same. So say the builder had the 2021 permission in his hand and was working out precisely where to put the panels in accordance with that permission, that couldn't render the 2017 permission unlawful, because the 2017 permission says precisely the same.
Well, my lord, and I was going to come to that, because I do not accept that, I don't accept that as a matter of fact that is the case. Because, and my lord, this is why it is important here that it was accepted below, that it would be physically impossible to complete the 2017 permission the moment the 2021 was begun. Because, my lord, it's not in my submission. It's not simply a case of looking at the plans and seeing something that looks on the face of it quite similar and saying, therefore, they are the same. those panels to the west of the line.
Mr. Burton, that you can't at 10 to 4 in the Court of Appeal take that point with respect, because it would be for you to identify the precise nature of the incompatibility. We've seen the transcript in front of Lord Justice Nugee. That was clearly a major issue. It was precisely the same issue as I had when I sat down to read these papers last week to try and identify the incompatibility. We've got there. It's the siting of the compound, the further panels to the east of the power line, and the fact that it's not 33 but the bigger compound. But there's never been any suggestion that the rest of the siting of the panels is any different.
My lord, my learned friend has only my learned friend has just now today said, well, what about if they just built that bit of panelling to the west? So that's it's come up today, and that's why I'm dealing with it. My case,
it's always been there.
My case below, and of course here, was about why the bits of the incompatibility that are so obvious that no one could have missed them. And that's why I've of course focused on the bits that are so obvious that no one could have missed them. And I should say, I don't say that just because they were obvious of itself makes the incompatibility a mandatory material consideration. It's made a mandatory material consideration by the combination of their obviousness, the reasons for the application, and the justification for policy compliance and granting it by the authority. But what, in my submission, my learned friend cannot do today is say to this court, not having done it below, having said below, one cannot begin the 2021 permission without rendering completion of the 2017 physically impossible. What he cannot say today is, well, those panels to the west, that section not covered by the compound are the same.
I think I put that to him.
No, you did.
Let me try the question another way. On the assumption that the panels in the south of the site, to take an example, are in precisely the same position in 2017 and 2021, do you say that a builder who started work on the 2021 permission, putting those panels in that location, rendered the 2017 permission unlawful because of hillside?
Well, if they're precisely the same in every respect, including the equipment and so on, and one would have to consider whether there's a material difference, then but if there's no material difference, then no. But with those caveats, my lord, and I do say, and however the point has arisen, I do respectfully say that it was not the claimant's burden.
It would be open to you to submit, just to see if we can resolve this in a way that is really within the four corners of the case we're dealing with. It would be open to you to submit, and maybe you do, that notwithstanding the conflict between the parties on their respective understanding of hillside, either way, there was a risk, and a real risk, I apprehend, you say, of a breach of planning control under that jurisprudence. And it was that risk, not any scale of risk, on a sliding scale from 0 to 10, as it were, but it was that very risk which was of itself, as a risk, a mandatory material consideration. And therefore, whichever side is right, you might submit. That's all I have to submit on that question. Now, I'm simply asking you whether that is the way in which you put your case or not. I simply need to ask you that.
It is the way I put my case, my lord, but yes. I say the case gets better and stronger if I'm right on hillside. Because the risk gets greater on that sliding scale of risk.
My only difficulty, and this is a genuine attempt to shed light where I can, so that I understand it. But I mean, you don't have to surmount any particular hurdle, if you like, hurdle of risk as a submission. For the purposes of your case, you only need to make good the proposition small is enough to found the proposition that this was an obviously material consideration of itself. And I'm simply asking really for that.
That's correct.
Clarification.
That
yes.
that is correct.
Yes.
Yeah. Yeah.
I didn't think you had to pursue the point.
Now, my learned friend has raised them, and so I feel I should deal with them. Now, my learned friend has raised what might be described as pleading points, which he's raised for the first time on his feet, not raised below, and not raised in his skeleton argument, and it's rather surprising in my submission that he does so at this stage in that way. Now, I say that my what I've called at various times a sequential error, the first error being a failure to have regard to the incompatibility, the second sequential error, a failure to have regard to the consequence, was always present. And in fact, my learned friend took my lord to paragraph 5 of the judgment, I believe, and said that that was a good encapsulation of the ground that was granted permission below. And of course it is, picking up the words, challenges the grant of the 2021 permission on the basis that the authority in granting it failed to have regard to such incompatibility, failed to have regard to the fact that the 2021 permission could not be implemented without a breach of planning control, and failed to grapple with the incompatibility or the consequence of it. Now, I can give my lords very extensive reference to the submissions I made to the learned judge below, in which I argued many times, as I have argued before my lords, that as regards the incompatibility, one had to look at the justification for the application and the authority's reasoning, including as to policy compliance. And I don't know if my lords want those references, but
see the references in the transcript, are they?
in the transcript.
Well, just if you just give us the references, we'll have a look.
So these are simply in order, and they're not in order as it were in importance, but they're in order. So these are all supplementary bundle references, 184 to 185. 189D, 200E to G, 201 G to H, and over the page continuing to 202A, 218F to H, 219G to H, and over the page to 220, 222D to H, 224A to B, 229C to D, 230F to H, 231A. I think it was that point, the judge told me to stop making the submission. He'd heard it so many times, didn't want to hear it again. And indeed, there was also referred to in the subsequent written submissions after the hearing itself. And it's an argument that is squarely within, I say, my facts and grounds 2A and 59B to C. I mean, yes, I elaborate an oral skeleton and then an oral argument. But in the skeleton, one needs references my skeleton below. I made clear the incompatibility was a stand-alone error of law. That's at CV 83, paragraph 45, and so on. I mean, well, anyway, my laws have the references. I don't say that this. I say this is not. It's not an appropriate point to take at this stage in proceedings. I just turn my back, my lord, please.
Sure.
Just to reassure Mrs. Fiske, my lords, we're going to, as my Lord Lindblom indicated, within 7 days, agree a chronology, an extended chronology, and submit the various representations, or whatever they
Yes, no, that's what we've asked for, and I think that's a reasonable timescale within which to ask for it.
Yes, so those are my submissions in reply, my lords. I'm very, very grateful.
Thank you very much. Thank you very much, Mr. Burton. Well, Mr. Burton, Mr. Green, thank you both very much, and our thanks, of course, extend beyond you to those who sit behind you and elsewhere, no doubt, who assisted in the preparation of the case. Thank you for your very clear written and oral submissions. You've given us much to think about. We're going to take time to reflect upon our judgments, which will be provided in draft in the normal way in due course. In advance of hand down for typographical and any merely factual corrections to be made at that stage. Your consideration should embrace then, please, a draft order and any submissions which may be consequential upon such disagreement, if any, as there is upon that order. Hand down will take place, as I've said, on a date indicated. In the meantime, and I stress this now, lest there be any misapprehension about it, embargo restrictions will apply, and they will be closely enforced by the court, should that be necessary. I'm sure it won't. Thank you very much, all of you.
Thank you, Madam.
Court rise if able.